Ellen Efros, take it away.
Take it away. I'd love to take it away. We have with us again today Danaya Wright, who you might remember from last year. She's an endowed professor of law at the College of Law. Dana has done a lot of work in taking cases, and I'm not talking necessarily about property cases of that kind of taking, but taking of rights or the reverse of that, situations where they will not take rights away from people. And there's one case that's very much on point from this last term, called Cedar Point Nursery versus Hassid, I think. And Dana's going to talk a lot about that case because it has implications go far beyond that case and will absolutely impact what the Supreme Court does in the next term in terms of taking cases. And you also might get a better understanding of what we're talking about when we talk about taking cases. So I hope you all enjoy the presentation. And with that introduction, I'll turn it over to Dana.
So thank you very much. It's great to be back. Again, I wish we were in person. But once again, we are on this delightful Zoom. But it does give me a chance here to, share my screen. So I've been writing about the takings clause for quite a while, and this case has really sort of shifted the court's direction and is one that I think is just a terrible, terrible decision on many levels. And I'm going to talk about it. I'm going to give you some history of the property protection, sort of what the court has been doing over the last couple hundred years with regard to property rights and property protections, and then sort of put this case into perspective. This is a case involving a landowner who owns, I believe, strawberry fields in California, hires 400 seasonal workers, and is subject to a California regulation that requires access by union organizers to come onto the land during lunch, an hour before work and an hour after work, to talk to the workers about union membership. And the labor law had been challenged a number of times and upheld as a legitimate labor law. And it was just recently that given the change in the Supreme Court, that opponents thought, oh, let's use the takings clause as a way to challenge this law. So this completely new novel argument about takings comes up, and I'm going to explain why I think it's wrong. But in order to get there, we have a long path through the Constitution. And let's see, let's go there. Okay, so when we think about, and I apologize this, I'm a legal historian. I just have to talk about the legal history here. So we know that there's two provisions of the Constitution that cover property protections. The first, in the Fifth Amendment, says, nor shall any person be deprived of life, liberty, or property without due process of law. And then we have, nor shall private property be taken for public use without just compensation. So there's these two provisions, the due process clause and the just compensation clause in the Fifth Amendment. We then have the 14th Amendment comes along in 1868 that also has a due process clause that is not in the passive voice. This one's in the active voice. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So when you juxtapose these two, it's kind of interesting to realize that the just compensation provision is only in the Fifth Amendment. The equal protection provision is in the 14th Amendment, but both have due process provisions. So what did we do with that? Well, in 1833 in Barron versus Baltimore, the Supreme Court held that the Fifth Amendment's just compensation protection applied only against the federal government, did not apply to limit state governments. And let's see, and that so as a general matter, sort of the law that evolved in the prior to the 14th Amendment was that due process would require that laws be passed appropriately, both by both houses, that they promote the public welfare. We don't need special interest legislation or arbitrary and capricious legislation. They need to not unduly deprive an individual of an important right, such as property, without a very good justification. So due process, the idea of due process was that it generally protected people from regulations, laws that might limit or restrict their property, but didn't really, it wasn't a taking, right? It wasn't an exercise of eminent domain. Just compensation, on the other hand, was a provision that applied in the narrow circumstance when government appropriates or seizes land or other property from individuals. So when they take land for a highway or they take land for a courthouse, we understood that that was an exercise of eminent domain, just compensation was due, and under the Just Compensation Clause, but that all those other regulations that are out there that might have some impact on property rights would be governed under the Due Process Clause. And moreover, that both of these clauses only applied as against the federal government. So if states were doing things like restricting property or exercising eminent domain, the remedy was under your state constitution, not under the federal constitution. So what happened sort of throughout the 19th century is we get this pretty general understanding that the Due Process Clause applies when property is being regulated, but just compensation applies when property is taken. Okay, now that obviously we know that what has now come to pass is this notion of a regulatory taking. So already there's something interesting is going to happen. We have this good split between due process for regulations and just compensation for appropriations, but that will eventually get turned on its head. Now, the 19th century judges were sophisticated judges. They understood that there were times when certain regulations could be so egregious, so far-reaching, that really what was needed was that it was a functional equivalent of a taking of private property. So we like to think that there's a clear line between a regulation of your property and appropriation of your property. But if we think about property as a set of rights, then if the government says you can't develop, for instance, you can't build a building more than 5 stories high if you're within a half-mile radius of the Boston State House, we can think of it as a regulation on your ability to develop your land, a limitation of some sort. Or we could think of it as an appropriation of your airspace rights over that particular space, in that particular space. But the 19th century, so regulation and appropriation under the due process and the just compensation clauses have always been a little bit fuzzy, where the boundary line is between a regulation and an appropriation. So 19th century judges had a pretty good sense that under the doctrine of eminent domain, which requires compensation, that there might be situations when a regulation rose to the level of becoming a taking, right? An appropriation. So limiting the building height of buildings within a half-mile radius of the Boston State House, prohibiting dredging might be considered a taking, and cutting of seagrass on riparian lands. When a regulation prohibits doing that, there was a sense that maybe that was that had risen to the level of an appropriation and would require compensation, as opposed to being understood under the Due Process Clause. So courts seem to recognize this distinction, though, between regulations what they developed, I guess, in the 19th century, was a distinction between regulations that prevent a landowner from inflicting harm on neighbors. Like you cannot pollute the waterways. You may not take too much water. You may not cut the grasses if that's going to increase a flood risk. That's a regulation that's perfectly permissible, does not require compensation, is not a problem, because we are preventing landowners from inflicting harm on their neighbors. But other regulations force a landowner to provide a benefit, like don't build a building too high so it casts a shadow. We want to keep the state house looking, majestic. And if we have too many buildings overshadowing the state house, it won't do that. So regulating a landowner to prevent that person from building too high, the court said that confers a benefit on the public. And so if the regulation is going to confer a benefit, then we're going to need to have some kind of compensation is likely to be due. Sorry, let me get my phone off here. So this became known as the harm prevention versus benefit conferring distinction. So regulations that prevent harm are fine under due process. They are not takings. And regulations that require the conferring of a benefit might require compensation under eminent domain. So that's where we are as we go into the end of the 19th century. But then, and I've talked about this before to all of you, as I think this is an incredibly important period, we have this Lochner Era period. So starting in around 1887 to 1936, the Supreme Court does these, it heightens protections for property by striking down legislation that regulates or restricts or limits how people can use their private property. So they did this both against the federal government and as against states. The court would strike down all of these sort of, a lot of the New Deal regulations, progressive era regulations as restricting property rights. We can't restrict property rights that much, right? Property is sacred. That's why we have we have the due process clause. Property is sacred. We cannot restrict too much. And so we get this period called the rise of the substantive economic due process theories. And smack in the middle of that period, in 1922, Justice Holmes faces a case where the state of Pennsylvania has prohibited coal mining under private land or public streets that might cause subsidence of the surface. And so the Coal Act says, you cannot, if you've got coal, you've got to leave enough coal in place to prevent the surface from collapsing. And under a due process analysis, Justice Holmes writes, fully and consistently with the sort of the law of eminent domain as it had developed, he says, government hardly could go on if to some extent values incident to property could not be diminished without paying for every such change in the general law. As long recognized, some values are enjoyed under an implied limitation and must yield to the police power. But obviously the implied limitation must have its limits, or the contract and due process clauses are gone. One fact for consideration in determining such limits is the extent of the diminution. This is the diminution in property rights. When it reaches a certain magnitude, in most, if not all cases, there must be an exercise of eminent domain and compensation to sustain the act. So the idea here was that regulations regulating private property are fine up to a certain point. Then after a certain point, if they're too egregious, they interfere too much in the property rights, or are too constraining, then the government needs to exercise eminent domain and compensate, take the property, right? So if you can't build in a way that casts a shadow on the state house, and that's just too much, too onerous on the landowner, then the state needs to exercise eminent domain and take that land and pay just compensation for it. But during this Lochner period, many regulations were stricken for violating this heightened due process notion, and for interfering with private property rights. But the Penn Cole case says, sort of starts to muddy the waters here a little bit by talking about how if the regulation goes too far, we might have to exercise eminent domain and pay for it. Well, that moves us out of the due process and into the just compensation clause. So starting in 1936, we begin, or 37, there's a repudiation of this sort of this notion of really strong heightened protections for property rights. And in West Coast Hotel, the Supreme Court backed off and they said, you know what, property regulations are generally fine. We're not gonna regulate those. We're not gonna strike them down. We need to have property regulations because when we don't, we have things like the Great Depression. So we get to this point, like by 1963, where the court says, we're not gonna sit as a super legislature to weigh the wisdom of legislation. We emphatically refuse to go back to the time when courts used the due process clause to strike down state laws, regulatory of business and industrial conditions, because they may be unwise. Nor are we able or willing to draw lines by calling a law prohibitory or regulatory. Whether the legislature takes for its textbook Adam Smith, Herbert Spencer, Lord Keynes, or some other is of no concern to us. And then they uphold this Kansas debt adjusting statute. They would say, oh, we don't care if it's wise or unwise. It's fine, right? So what the court does at the end of the Lochner period is to pretty much say the due process clause does not restrict regulations of property. It just doesn't, there's no restraint on state, local, or federal governments in terms of how they might pass laws that are going to have significant restraints on property. But then, of course, starting right about 1960 is we begin to see a slew of environmental statutes, right? This is just a few of them between the Air Quality Act, the Clean Air Act, the Clean Water Act, the Endangered Species Act, and it just goes on and on and on and on and on. All of this federal regulation is regulating how people can use their property, right? How they can use their land. And landowners are not happy about that. Especially developers are not happy about that. And we get another funky little case in 1960 where the court says, and this is just a weird one-off case where the federal government entered into a contract with a shipbuilder to build Navy ships. And they had a provision that said, if you default, we're going to take ships. We're going to take what you built. We're going to confiscate the partially built ships. The builder defaulted. The federal government took the ships, and material men, subcontractors who provided services for the building of the ship, labor and materials, ended up losing their liens. Right? They didn't have their rights in the ships were cut off by the federal government taking possession of these ships. So that case went up to the Supreme Court where these subcontractors claimed that their property had been taken, that it had been appropriated. But it wasn't appropriated in the same way you appropriate land for a highway or a courthouse. And so the court came back and said, yes, this is a taking. But what they said is interesting. They said the Fifth Amendment's guarantee that private property shall not be taken for a public use without just compensation was designed to bar government from forcing some people alone to bear public burdens, which in all fairness and justice should be borne by the public as a whole. So now we have these two cases, the Penn Cole case from 1922 that says regulation that goes too far may require compensation and an exercise of eminent domain. And then we have the language here in Armstrong that says government action, when it forces some people to bear a public burden, that in all fairness and justice should be borne by the public as a whole, is going to require compensation, even if it's not the typical appropriation of land. So now we're beginning, you can imagine the Clean Air Act, right? Let's say the government tells a landowner, you can't build a factory here that's going to belch air pollution. Under the 19th century law, that's clearly would have been fine, right? It would have been fine because under the 19th century distinction between harm prevention and benefit conferring, telling the company you can't belch pollution is preventing harm. And that's okay. And compensation is not due. And there's no constitutional problems with telling people that. But under this idea that we're telling a landowner that you have to stop doing something because it's going to benefit the public as a whole by having clean air, they latched on. They could say, well, under Armstrong, you're asking us to stop belching fumes in order to protect the public as a whole. You need to compensate us for that. Now that made no sense based on the 19th century jurisprudence, but it begins to make some sense given this language that regulation, if it goes too far, might require compensation. And then we get to 1978, and I'm almost done with these. And in 1978, in the Penn Central case, New York City had designated Grand Central Station as a historic landmark and prohibited further, you can't tear it down and you can't build a building over it. You can't change it in certain ways that would destroy the exterior facade of Grand Central Station. And that's the first case where the court recognizes this idea of what's called a regulatory taking. A regulation that would normally be evaluated under the Due Process Clause might rise to the level of a taking, that we can take property through regulation and require compensation as a result of it. And the court said, we recognize that there is this potential thing called a regulatory taking, but it really involves, whether the regulation goes too far, involves a three-part analysis. Looking at the economic impact of the regulation, particularly the extent to which the regulation has interfered with distinct investment-backed expectations. And, oh, I forgot one, the character of the governmental action is the third one. So starting in 1978, we get this sort of new idea of a regulatory taking. And we're going to balance. We're going to say, is this regulation, does it go so far that it's unfair and it's asking a private individual to confer a benefit that ought to, in all fairness and justice, be borne by the public as a whole? So it's this really interesting transition from the 19th century, fairly clear line between regulations and appropriations to what we now have is this regulatory taking, which blends the two doctrines. So we get, after 1978, the court just goes crazy about regulatory takings. They're like, this is the best doctrine ever, because they can't use the Due Process Clause anymore to strike down regulations that go too far. They end up using regulatory takings, kind of becomes the new tool to rein in government regulations that landowners feel are too onerous. Now you get this crazy sort of jurisprudence where the court says, okay, if we have 100% economic loss, or we have a physical invasion caused by the regulation, it's a per se taking, compensation is due. In everything else, otherwise it's a matter of ad hoc balancing, the balancing of the factors that we saw in Penn Central. But then the court they just can't seem to really decide whether they really believe in this doctrine or not, right? This made up doctrine, they completely made up. And the Phillips and the Brown decisions are a really good example. So in 1998, in the 90s, there was a program that said, if you're a law firm and you are required to have a trust account. So if somebody pays you $1,000 retainer, or they want you to hold funds in escrow, you have to put that money into your special trust account. Now, most of those payments, most of the amounts of money that people put in are not sufficiently large to generate interest. But when you aggregate it all, now you've got an account that might earn interest. And the states decided that we'll take the interest off these accounts and use it to fund legal services for the poor. So it's called the interest on lawyer trust account laws, and all the states passed them. And that law went to the Supreme Court, and the Supreme Court said, well, we think the interest on these accounts is property. And therefore, you know, there was the argument that it wasn't really property because it's not the lawyer's property, right? Because it's not the lawyer's money, but it's also not the client's property because the client would not be entitled to that income had the client simply invested the money himself. It's only because of the law requiring that we aggregate the funds into these trust accounts that we even have income at all. But the court decided in 1998 in a 5-4 decision that this is property, but they didn't address the question of whether the statute took the property. And in 2003, when the exact same case made it back up to the Supreme Court, they decided 5-4 that it wasn't a taking. So what the court has been doing since 1978 is they'll decide a case and we all go, oh no, they're going to decide that that's a taking. They'll decide some sub issue and then send it back down and it comes back up and then they say, okay, no, that's not a taking. We were just kidding. So you have these completely contradictory cases and decisions that almost impossible to reconcile. They did the same thing in the Tahoe Sierra case where they held that that involved regulations about development around Lake Tahoe. They did the same thing. It's like in 97 you think, oh my gosh, we're about to find that this regulation is a taking. And then the next thing you know, they say, oh, no, we were just kidding. This one's fine. And it's this whiplash that the court is giving everybody in these cases. But I also think about the remedies. Okay, so usually a due process violation calls for repeal of a law. A just compensation clause violation calls for compensation. But most of the people who are complaining about all this environmental regulation, the development limits, the fact that you have to get approval from the Army Corps before you're going to dredge or build, they just want repeal. But they're using compensation claims to challenge the government and really get the government to back down. And so there's some problems with how we think about what the proper remedy should be from this potential constitutional violation of regulations that are particularly onerous for some people, but not for others, that might confer benefits. So if you're told you can't develop because of the pollution or the external traffic, should government compensate you because you are conferring a benefit on your neighbors? Or you're conferring a benefit on the public? Or should they not have to compensate you because they're preventing you from imposing harms on your neighbors? Right? It's a really abstract, complicated jurisprudence where what limitations the Constitution should place on laws regulating property, in particular land. So it's just a big mess. But they have one area where they've said per se taking, absolutely. And this is the physical occupation cases. So we have in Kaiser Aetna in 1979, private developers, this is the bottom picture, they dredged a shallow lagoon to create a private marina. But once the waterway was dredged enough for ships to come in, now it became subject to the federal navigational servitude and they couldn't exclude the public. And so Kaiser Aetna claimed that now we have to let the public into our private marina. That's a taking. It's a per se taking because you're forcing us to allow the public to come in. We cannot exclude them. We can't charge them is really what that's about. And so that's a per se taking. In 1982, they said that a New York City law that requires that landlords of residential buildings in New York had to allow permanent cable. Remember those cable boxes, those little cable hookups? You screw it in and you run the cable from building to building for your cable TV. They held that that was a permanent occupation, a physical invasion, and required compensation, even though it's a space that was about, that big. Compensation would be due. It was a per se physical occupation. In 1997, in Nolan, we had that's the middle picture. Mr. Nolan wanted a permit to build his beach house bigger, his little beach bungalow, make it much bigger. And the California Coastal Commission thought, look, if everybody keeps building these big houses, they're blocking the view of the beach. They're making people feel like there's this barrier. So we'll give you your permit to build your bigger building, but we want you to give a lateral beach access along the beach for the public to traverse your land. That was held to be a taking of this lateral easement for the public to go along the land. And finally, Arkansas Fish and Game in 2012, the court held that intermittent flooding of land above a dam constituted a physical invasion. So these are our physical invasion cases that the court's going to rely on in our Cedar Point case. So now we get to Cedar Point Nursery versus Hussey. So we have this strawberry grower. They employ 400 seasonal workers, 100 full-time workers, and they claim this is a regulatory taking. It's because it comes from a regulation, but it's a taking of their property rights because it's taking an access easement by the state when it requires that they permit union organizers onto their land. Now, this is sort of a crazy argument, but it's going to work with the new Supreme Court. So the statute here that says, I have the language here, the board will consider the rights of employees under labor code section blah, 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 to include the right of access by union organizers to the premises of an agricultural employer for the purpose of meeting and talking with employees. So this is the law that's about to be, that we're addressing as to whether or not that is a regulatory taking. Now, just pause for a minute, because when we think about the cases in the past, right? The cases that prevent developers from overdeveloping, the cases that prevent the landowners from a lot of our environmental regulations, right? That prevent, polluting the waterways or polluting the air through their development or their use of their land in their own way. Those cases make sense as, okay, maybe sort of makes sense under this doctrine of regulatory taking, that we've taken away their property right. But the idea that a landowner has to allow union organizers onto their land is a really kind of stretch. That's a taking in some sense. So is this access requirement a physical invasion? And I went through the 4 cases, Loretto, the cable case, the lateral beach access case. You can see on the right-hand side, it's a 6-3 decision. These are our dissenters, the 3 justices in dissent, while the Chief Justice is reading his majority opinion. They are not happy with the way the opinion goes. And Chief Justice Roberts, in a 6-3 opinion, says, yes, California labor law authorizing a union representative to enter the plaintiff's land is a per se taking of an access easement. Now, this case just sparked a lot of interest by everybody because, of course, if you operate a restaurant, the health department has a right to access your land. If you operate a daycare, right, licensing boards have a right to enter, inspectors have a right to enter your land. If you operate a factory, OSHA inspectors have a right to enter your land. There's a whole police, obviously, building inspectors, lots of people have what we call access rights to land. And nobody has ever argued that the right of access is actually a taking of a property right, much less been successful in that argument. Now, Justice Roberts, I think basically they don't like unions. So they're willing to say a union access is a taking, but now they've got to somehow draw a line between the police and the fire department or the OSHA inspectors having access to land. That's going to be a tough one for them, but he tries to distinguish it. I don't think he does a very good job. The dissent, on the other hand, Justice Breyer wrote in dissent, and he said, this is not a physical occupation. This is not a physical invasion of land that's subject to our physical invasion cases. This is really an intermittent thing, and we should just use that Penn Central ad hoc balancing approach, not a per se rule. And when we do that, we see that, well, there's really no economic impact to the landowner. There's no particularly, no interference with investment-backed expectations. There's really no harm to the landowner comes from this union access requirement. And so if we did this under Penn Central balancing, there'd be no compensation. Now, the dissent, according to Danaya Wright, on the other hand, would say, absolutely, this is a terrible decision, right? Because, this is not a taking, because there's a huge difference between rights of access and the grant of an easement. What happened in this opinion, and what happened in this whole case, is that the plaintiffs kept arguing California is giving unions an easement over my land, and an easement is a property right. And they're taking that property right from me and they're giving it to the unions. And I say, no, that's not how it works at all. An easement is a right to go onto someone else's land, but it depends on and is based on where the land is located. So if I have an easement, over my neighbor's land as a driveway, it's because my neighbor's land is right next door to mine. That's what makes the easement an important property right. For instance, if I want to build right on the beach, and now I have to give an easement to people to access the beach, it's because my land is next to the beach. So easements are related to the location of the land on the ground, right? So we're not going to take an easement for just everybody to allow for upland flooding from a dam. Only the landowner whose land is upland of the dam is going to have, it's because of that location of the land up from the dam that we need an easement on the land for flooding. Access is completely different. Access is about how the landowner makes use of his land. So if you want to grow strawberries on your land and hire migrant workers, then you have to allow certain inspectors. If you want to use your land for a restaurant, you have to allow the health department. If you want to use your land for a shopping mall, you have to allow people to exercise their speech rights on the land. If you want to use your land for a preschool, you have to allow inspectors in. So the access requirement is not about the location of the land, where the land is located. It's about how the landowner is choosing to use the land. So I would argue that the Cedar Point Nursery would not have to be subject to the access of the union organizers if they weren't running a strawberry farm on it, where they were hiring migrant farm workers. When you choose to do that, you choose to use your land in a particular way, then you may be subject to obligations of inspectors being able to come in. Now, this is all over the news, whether this case by finding that this law takes an easement, are we now not going to be able to justify inspections, health department inspections, or OSHA inspections? I mean, it really does rise to this level of potentially undermining the entire regulatory state. Ironically, the regulatory state. So what are the implications of this case? It clearly voids all union access laws under the National Labor Relations Act and various state labor relations acts by basically saying this is a taking of a private property right and you owe compensation, I guess. Although they didn't ask for compensation, they just asked for that the law be repealed. I think that it really calls into question many of our access requirements, like the police, the fire, the OSHA inspectors, the building inspectors, the legal aid workers, et cetera. I think those are really at risk right now as a result of this decision. And I think it defines access rights as a property right that I think is going to have unexpected implications going forward. You know, I have a right to go to Publix. They can't exclude me, right? Just because they don't like who I am or they don't like my politics. But if the court says that any law that requires a civil rights law that says Publix can't discriminate against me on the basis of my politics or my race or my sex or my sexual orientation or anything, arguably Publix could come back and say, that's a taking of my property right. You're taking an easement for all of those people that we don't want to have come into our store. You're taking a property right from us and you have to compensate. So I'm not convinced that we're not going to see some pretty significant implications going forward of our civil rights laws as a result of calling this right of access, a taking of a property right, because then we fall into this notion of a regulatory taking, which is a completely made up doctrine, but it's one that seems here to stay. And we've just gone, until just recently, I would say, the court has been doing these 5-4 decisions, relatively split. We haven't seen a significant push into the area of recognizing all regulations as essentially takings of property rights. But now with a 6-3 majority, conservative majority, I'm not so sure we're not there yet. So that's the end. I will stop my share, and I'm sorry I talked so long, and I hope it wasn't too much, but this stuff is just sort of mind-blowing at times.
Thank you. I do see a question in chat. Would you like me to read it to you? I don't know if you can see it.
I can. Oh, I don't.
I can read it.
Yeah, you'll have to read it. It's not in my chat.
Okay. Is zoning considered a taking, or does the argument hold up as expressed by if you bought a wetland, you must have wanted a wetland?
Right. Good, really good question, right? So the challenge to zoning, because zoning happened around the 1920s is when it started to really kick in this country. The courts were poised to strike zoning down as an unconstitutional interference with property rights. And apparently they worked out a deal that said, all right, we will uphold the general zoning power because it benefits everybody, right? It benefits, my land is restricted, but I'm also benefited by your land being restricted. And so we can sort of talk about a reciprocity of advantage here. And so the court allowed, fairly narrow decision, allowed zoning to be permissible. But then they started striking down a whole bunch of very specific applications of zoning. So I think that horse is out of the barn. I think zoning is generally going to be okay. But what it does is by strengthening this idea of property rights, every time the government does anything that restricts my property rights, they need to compensate me because they've taken something of mine. I think we're going to see more challenges to particular zoning actions as not having a sufficient benefit. You know, if more of the burden falls on me than my neighbors, oh, well, then I should be compensated. Right.
Thank you. Anne Marie, go ahead.
Yes, thank you. I'm aware that the cases that you've cited are private sector cases. So you have the strawberry farm and so forth that's cited. And the question is often whether or not those who are some entities that are private and some entities that are public, like police officers, can have access. But I'm wondering, you know, I've studied, you know, the idea of public good for a long time. And what I see here is a real erosion of what the public sector is, that delineation that used to be, to me, much clearer between public and private sector. And I'm wondering if you foresee cases like some of the threatened parks areas where there are hunters that go on to public land and claim that they can do whatever they want because they're members of the public and that sort of thing. And thereby use this as kind of a hook that will get them into getting rangers off their land, off what they see as their land. You see what I'm going with this?
Yeah.
I mean, I think it opens a whole can of worms. And I am upset enough about an erosion of the regulatory state on these grounds, but the whole idea of what it means to have a public sector organization, I mean, I'm sure that's going to happen with coastal zone, you know, all the beach protections that developers, you know, are going to love to take that when they already are.
That's right.
Comments on that, please, where you foresee this might go.
Well, I'm not sure that it'll go to the point of like the hunters. I think they have other claims that might be more successful for them. But I am very worried. I think what Justice Roberts is trying to do is he wants to say, look, the union is another private entity. And so we're basically taking a private farm and we're saying you have to let this private entity come on. And they're going to try to hold the line and say, you know, the government inspectors, the government, the police, the fire department, those are government entities and they will have a right of access, but not this private entity of the union. And so I think they may be able to maintain that, but where I don't think they're going to be able to maintain it are your civil rights laws, right? So when publics can't exclude me because of my race, we could say that's a public harm. But in fact, it's really a private benefit, right? To the people who want access to Publix or the theaters or, you know, the Gator football stadium or whatever. That's where I kind of see. So you have this whole body of cases on property rights, which, yes, we have strengthened property rights way more than we should. And that comes at the cost of the public, right? We also have these access rights that we have strengthened to a certain extent at the cost of private property rights. So my right to speak, exercise my First Amendment rights in the Oaks Mall, in private spaces, right? Or my right to picket a private business. Those rights had been strengthened. I see those rights really being narrowed by this case. And we're doing fine on strengthening those private property rights. So the hunters they're already good to go.
Thank you. John, go ahead.
This may be unrelated to this, but I'm always wondering about the communities that have a sign saying no soliciting. Granted, I think the Fuller Brushmen, if any of them still exist, it makes sense to them. But I solicit people's votes sometimes by canvassing a neighborhood. And I get pushback from some of the residents who say, didn't you see the sign? And so I'm just, and in this case where we have a union group, they're not selling anything as such. They're just soliciting votes for the union. So how does this impact that sort of situation? In fact, I've looked online, and the soliciting for political soliciting, I can get views both pro and con. It's not clear. Yeah.
Yeah, that's interesting. I always thought those anti-soliciting bills were, or, you know, the laws that allowed you to put your anti-soliciting thing out were aimed at people trying to sell you things, right? And so that wouldn't apply to the postal delivery person or the person soliciting and trying to sign people up to vote. But I don't see why, you know, a landowner could say, I don't want anybody coming onto my land. You know, they can shut the door in your face when you're right, when you're soliciting voting. But most people aren't antagonistic to that practice. But landowners, you know, that own factories are very antagonistic to the union organizer. So yeah, that's a good question. I hadn't taken it that direction.
Thanks.
Mm-hmm.
Okay, Rick Gold, go ahead.
Hello, thanks so much. The union movement has been fighting for their rights for 100 years and made significant progress, but occasionally find themselves with some real challenges. How are they reacting to this decision, and how are they adapting to it?
They're very upset. Obviously, they're very concerned. And, you know, we've already seen the Supreme Court eroding union rights in other ways. There were some other union cases involving the rights to like use company email to solicit union membership and those sorts of things. And the court has been striking that left and right. Now, their argument for why the National Labor Relations Act no longer is necessary, I think, is not that we don't need unions, but that there's so many other ways to access workers. Every worker now has a cell phone. So you don't need to come on the landowner's property because you can just send everybody a text or a tweet or whatever. That's the argument that's being used, is that we don't have to give unions access to the company email or to the actual land because they can get access in other ways. And I think they are quite correctly claiming that that's not, that is an ineffective form of communication. That if you can't meet the worker where they're at, then it really isn't adequate forms of communication. So that's where I've seen them really upset about this decision, is that it's based on this faulty assumption that you can reach the workers in some other way other than face-to-face.
Okay, thank you. We have a question here from the Oak Room.
Yeah, this is challenging. I hope I can sort it out well enough to ask a question, but it occurs to me that right of access has a bearing on mask wearing and vaccinations and that. Can you help me sort that out as it applies to public schools, private schools? Some of those cases are going to go somewhere because there's a lot of dispute.
Right. So I think it's interesting that since the Reagan era, landowners have found a very receptive court to claims about property rights. So I think this isn't going to affect things like a public school mask mandate, but they could very easily affect claims by the private Ace Hardware down the road, where the Ace Hardware says, no, you can't wear a mask in here, or yes, you must wear a mask. If the state law contradicts what the local business wants to do, I could easily see this kind of case being used to justify the private landowner's rights to say, if you're wearing a mask, you can't come in. But they could also be used for the private landowner to say, if you're not wearing a mask, you can't come in. But we know which way those are going to go, right? Which ones are going to bring suit and which ones aren't. So I think we have to keep, this is really a strengthening of private property rights. So it's going to be there have been most of the entire 20th century and the first part of the 21st century has seen a general decline in this idea that property rights are these robust and absolute right to exclude. Now, clearly, I can exclude people from my home, from my living room. I don't have to let John in to convince me to vote, right? I have that kind of privacy and control over my private property. But once I start, opening up a Publix, or I bring migrant workers onto my land, or I have a factory, or I have a preschool, the assumption has always been, once you dedicate your land in a particular way, your rights are limited now. Your rights are constrained. And what the court is doing is they're shoring those rights back up. And I think that's incredibly dangerous when we think about human trafficking. We think about the ways in which bad people, right, are trying to use their property rights in ways that really restrict and injure and hamper the ability of others, right? So to be able to say, my property rights are so much more important than your right to shop in a safe environment where everyone's wearing a mask, right? My property rights are that much more important. That's where I think the problem is. It's about this assertion of property rights that can really destroy people's lives, quite frankly, but certainly their livelihoods, their interests, and all in the name of this almighty abstract property idea of my right to exclude that we've never really had in this country, right? It's never been part of the law, and yet the court sort of gestures toward it and is constantly strengthening it.
Are you good on time for a few more questions?
Oh, sure, absolutely.
Okay, good. Lynn, go ahead.
Thank you, Danaya. I thought that was a very interesting talk. It occurred to me that there's more and more privatization, if you want to call it, or use of private people to do inspections, whether it's your cable company or whether it's some other kind of function. Does the delineation between public there and start to get hazy and with respect to the implication of what you're talking about? Could you elaborate on that?
Absolutely, I think so. I think we have, so if to the extent we see the migrant farm or the union organizer and the strawberry farm owner as two private individuals, right? Once we have private building inspectors, I could see at least a claim being made. I'm not sure that the court would want to go that far. I'm more concerned actually with things like the private prisons, right? So where private landowners are doing things that were traditionally functions of the state, like a private prison, that now they're going to claim private property rights are so sacrosanct that you can't have the news media come in, for instance. Now, they probably won't be able to stop the food inspectors or the police from coming in, but I could easily see them saying, this is my private land, and I don't have to let the media in, just like I don't have to let the union organizer in. So the media ought to be very upset about this decision.
Thank you, Tom. George, go ahead.
Yeah, well, thank you for a great presentation. Looks like it's the ghost of Cesar Chavez in all this. But say if the workers decided to join the union and become a closed shop. And in the process of doing that, the National Labor Relations Board has to have access possibly to the property. And if they become a closed shop, the shop steward. So how would this decision impact those activities?
I am not a real union expert in this regard. I don't know. It has been articulated at this point, and the prior union cases have been about employers versus the unions, and the employees kind of get lost, but it's really about these big unions that are overfunded and completely unreasonable, and these poor private employers who are who are picketed and they're now invaded, and they're just so abused by the union. So I don't know what would happen if we started to see more, and I think we are starting to see more unionizing. But clearly employers are using their property rights to prevent that. So we saw that, I think, with the Amazon vote in Alabama. This is major dollars to employers to be able to limit the unions. And clearly that's what this case, I think that was a lot of what was underlying this particular case, and why the court was willing 6-3 to claim that this law was an overreach. But the ramifications are tremendous. So I honestly, I don't know. I can't answer your question about the closed shop and access and what the shops do.
Be interesting if it happens.
I know. I'm curious to see. Right, this decision just came down. I'm curious to see what happens, because clearly the National Labor Relations Act has been around for a very long time. And if now we've suddenly decided, oh, well, this is a regulatory taking. Wow, that's after 50 years, 70 years, I forget how long it's been around. Yeah, it's a big deal.
Thank you.
Mm-hmm.
Well, thank you. I don't see any other questions on this end. Ellen, any final comments?
No, nothing final, but thank you very much, Dana, for sharing this with us.
Sure.
I think you and I both believe that there'll be other cases this term involving takings, and that the court will keep enlarging the rights of those who argue the other side of the spectrum.
Yeah.
So I think we're about to see some very interesting interpretations of what the takings law means and what it doesn't mean.
Right. And as you are watching these new cases come forward, I just want you to think about the sort of the historical distinction between using the due process clause to analyze regulations and the takings clause that really only, the just compensation clause, that really only applies when we appropriate land, and how the court has blended those into this really bizarre doctrine that what they're trying to do is basically say that if government wants to regulate you in any way, they're going to have to compensate you, which it's just absurd, right? Even though Justice Holmes said government could hardly go on if it had to pay for everything it does. So it's a real challenge. This is an unbelievable challenge to local governments at a time, and this is where I see the problem, sorry, I know y'all want to go, at a time when climate change is forcing local governments to impose greater and greater restrictions on building and development. And so it's kind of like we were in the 70s when we had all of these environmental regulations because the environment was such a mess. Now we've got climate change disaster regulations that are going to kick in, and we've got this heightened sense of private property rights. That's where I see the real impact, although obviously the union issue is, and the free speech issue, I think are going to be really major as well. So on that cheerful note, thank you all.
Which will make us all feel better about where this is going.
Yeah, I'm sorry. What can I say? Thank you so much for having me again. It's always a pleasure.
Well, thank you. Thank you for sharing your time with us, Dana.
Sure.
Everybody have a good afternoon.
You all too.
Thank you again.
Sure.